DM. Ms. Tinsley, there are two motions before the court. I guess my first question will be on the Revocation of Parentage Act. You guys were married in 2013 and separated in 2016, correct?
Yes.
And the child that you're asking to be stated as born out of wedlock, you've got is 6 years old. When was the
Yes.
child conceived?
August of 2017.
All right, if you guys had been divorced already, and it is, when was the judgment was entered on, November 17th of 2017.
That's when it was finalized. But I went through our divorce decree and
Yeah,
I saw that we already signed something like that. So I don't know.
right.
I can.
That's what I was kind of wondering. I think, yeah, wasn't there, this was done long ago that the child
Yes.
was determined out of wedlock.
Yes. Well, when I tried to get child support from the other dad, they told me that he was still technically the legal father because they said they couldn't find the paper that we signed.
Interesting. Because I find a motion. I do not find an order from that motion. Were you actually heard by the court?
Yes. Yep.
Miss LeVay, could you pull up and see if there is an order? Wait, no, hold on. Yeah, there is an order dated September 7th, 2018. So what you need is a copy of that order.
Oh, okay. Did you say 2018?
Yeah, it was signed in September of 2018.
Okay.
The motion was filed in August of 2018.
Okay.
Okay.
So how do I obtain a copy?
Right. I'll have my clerk send you a copy.
Okay.
But yeah, I'll note this in the file and then I'll have my clerk send you a copy.
Okay.
Okay, that one's done now. That's why I was kind of confused. I didn't see the order either. It's buried later in the file.
Okay. Got
I
it.
saw the motion, but I didn't know if it had been heard, and I'm like, this doesn't make sense. So in any event, though, any questions on that, Mr. Beeman? Probably not. That one was not really you.
Yeah.
Okay, you have to unmute, Mr. Beeman.
Okay, can you hear me now?
Yeah. I didn't think you had any
Okay.
questions on that one.
Yeah, no, I don't. Sorry about that. I never
No,
used
no, no, no.
this app before.
No problems, no problems. Now, the other motion is a motion for child support, and the time has lapsed, so I can send it to the front of the court for a review. So it may go up, it may go down. Be careful what you ask for. It's
Okay.
under your current circumstances. Okay. So they
Okay.
need your most recent pay stubs and what's going on with the kids. And Mr. Beeman, do you have any new children?
I do have new children. I have
Okay.
two 5-year-olds that
Okay.
one lives with me
Okay.
right now, and
And they're yours biologically.
they're mine biologically. Yep.
In that case, those will come into play as well.
Okay, and I had a question. Does everything else that comes out of my check, does that come in an account too? Like say garnishments, my rent,
No, they plug it. The only
my
thing that comes out,
bills.
the only thing that comes out of your check, according to the front of the court, is taxes.
Okay.
Union dues are accountable. Taxes are
Okay.
accountable. Anything your employer forces you to pay. Some people have to pay for
Gotcha.
their uniforms and stuff. So if it's
Okay.
mandated by your employer, yes, that
Hmm.
can count. Garnishments, other things do not.
Okay. And
Okay.
as far as me requesting more overnights for my kids, would I have to go to the friend of court for that?
Yeah, you'd have to file a motion to do that.
Okay, not a problem.
All right. No
Yeah.
problem at all. Well, I guess I'll see you again in about 2 to 4 weeks then on that motion.
Okay.
Okay.
Sounds
And
good.
Yeah.
I just wait for that in the mail to come, or
Well, you could wait for I'll send you the order, and the front of the court will be contacting you shortly, within 2 to
okay.
3 weeks for the child support review. All right.
Okay. Thank
All
you.
right. Thank you.
All right. Take care. Good luck to both of you.
Okay. Thank
Thank
you.
you.
Weird how the front of the court couldn't find the order either, but then again, I had a hard time finding it. So it is in the file though.
Okay.
All right. I guess this matter's been being worked on since 2023. The court thought it made a order in accordance with the best information that it had on March 11th. It appears that some of that information may have been incorrect from what Mr. Nordland has found. Ms. Nordland, did you read the motion? Ms. Nordland?
Yes, Your Honor, I did read the motion.
Okay. All right. Because we've got, what, 3 different bills here. Do you happen to have the checks that showed what you paid?
No, Your Honor,
Why not?
because I pay by credit card.
Okay, then do you have the credit card statement showing what you paid?
No, Your Honor.
How do you not have the credit cards?
I do have the statements, Your Honor.
Okay, then why aren't they on the statements? Because what he's found is that you may not have paid anything. And then we charged him for reimbursement. I need evidence that the payments were actually made. I mean, we're at that point. That's where we were at the first time. He said he wasn't sure. And we were going off the best information we had at the time, which said you would be billed or were billed. You stated you paid. Well, now he's got information from at least one of the providers that says there was no billing. They didn't bill for that. They billed no uninsured medical.
Your Honor, I also have personal medical expenses through the same system. And
Okay.
so if I overpay, because sometimes they charge you.
Well, you don't get reimbursed for an overpayment, and you don't get reimbursed for what you pay. I can only have him charged for what the children pay.
Yes, Your Honor. So if
Okay.
I've overpaid for a personal medical expense and then that credit is applied toward a child's medical expense,
Then where's the paperwork that shows that?
the insurance paperwork that says I was billed and paid for.
But we've got a provider saying you were not billed for that. It said it did not bill you for uninsured medical.
So the information that Mr. Norland has provided is coming from the health system that
Right.
does not delineate between payments that I make for my personal health care and the children's health care. And I also submitted evidence to the front of the court several motions ago regarding the fact that Mr. Nordland also received refunds for payments that he submitted credit card statements for as evidence of his payments.
Have you received refunds, sir? Mr. Nordland?
I haven't seen anything provided by the plaintiff or the front.
I didn't ask of anything from the plaintiff or the front of the court. I asked you if you received reimbursements. You're the one that would know.
Right. They're
not going to come from the front of the. There was one, and what was it?
But not
in what amount?
It didn't seem to be applied to any. I couldn't find anything related to this.
All right, ma'am. Can you get anything from the providers that show that they've applied overpayments?
The last time I contacted the health system, the information that I received was a grid of refunds to credit cards with the last 4 digits of credit cards.
And those would be your credit cards.
They were Mr. Nordland's credit cards. And
Mr. Nordland, are you having credit cards pay this too?
I'm not familiar with the information she's providing right now, Your Honor. This is the first I've heard of that.
Which credit cards of his are being billed, and how are you billing on his credit cards?
2 motions ago, Your Honor, Mr. Nordland alleged that he had been charged by the FOC for charges that had not in fact been paid. And instead of providing statements from the insurer, he was allowed to provide credit card statements as sufficient proof of his payments. Subsequent to that hearing, I provided to the FOC evidence from the health system that he had received 3 separate refunds for those charges.
And how are you not familiar with that, Mr. Nordland? Because like I said, this has been going on since 2023.
Right.
We have vetted this out at least 2 other. No, this isn't the first time you're hearing it. If it was done before.
No. I researched as much as I could, and I could not find anything applied as a credit to these. And if there is evidence of that,
I'm going to go with my original thought on this, which was I had a hearing on March 11th. All the information was provided that was provided at that time. There was a 21-day appeal period on that. If that didn't go very well, then there was another appeal period to the appeals court. This matter is now closed. I'm not going to play games with this. It was a game the first time we did it, and it was a bad one. So I believe we even adjourned it for the front of the court to do further investigation. I'm done with this one. I suggest you guys figure out and start keeping better records if you're going to ask for the front of the court again, because I may look at them and say, I'm sorry, but I'm going to take you out of this. And we're not going to get involved because you guys have done this in such a manner that it's hard to tell what the hell you people are doing. So the court's not going to involve itself in the minutia here. We're talking about $71. I'm done. The order stands. That was issued on May 11th after a full hearing. Have a good morning.
Thank you, Your Honor.
Good day, Your Honor.
Good day. I believe the court has wasted over 6 hours on this issue for $71. And they have convoluted it so badly, and neither one of them can provide the proof necessary to make an actual decent decision. 1DS. All right, next, Ms. Rubio, this is your motion for support. What's going on?
So in April, he got a third shift job, and I agreed to watch the kids until he got a sitter.
Right.
Then he never got a sitter. And then, so for the last 4 months, I've had them on Thursdays overnight. And I did find a sitter for him, and he still didn't want to do it. And then also in
so you're basically doing his parenting time on his behalf because he can't find babysitters for his work.
Right. Well, I found him 3 babysitters, and he doesn't want to drive. So
all right, Mr. Rubio, what's your, because child support is based on what the actual overnights are being utilized.
Right.
So if you're not utilizing those overnights and she's doing them on your behalf, free of charge, then the child support issue is ripe for review.
Okay.
So I'll be more than happy. That is your motion at this point, Ms. Rubio, to send for the child support review due to the parenting time changes. All right?
Okay.
Good luck to both of you. How long do you think you'll be on third shift, Mr. Rubio?
I don't know. I didn't have any plan on leaving.
Okay.
So,
well, I used to prefer third shift, so I can understand. There are some of us that are built for that, some of us that are not. I miss third shift.
I've had to adjust to it, and you know,
they thought about doing a night court in Kent County at one time, and I was like, "Can I volunteer?" People looked at me like I was nuts, and I'm like, "No, I'm a night owl."
Right, right.
If I see the sunrise, it's because I've stayed up all night to see it.
Right.
But in any event, that does make a change of circumstance for review of the child support. Okay. Good luck to all of you.
My
yes.
question too is, when in May he foreclosed on the house, and so now he lives with somebody else. Okay. But on his weekends too, he's having either my mom or my sister watch the kids.
You didn't put that in a motion, ma'am. You put child support in a motion, not parenting time.
So I'm just asking now, what do I do?
No, it's not irrelevant. It's very relevant. The question is, facts like that to change the parenting time, which can change some other stuff, need to be alleged so that the other side has the right to refute it. In other words, you don't bring it up in verbal conversation after you filed a motion for child support and say, let's throw in the kitchen sink with all these other allegations that the other side is not prepared for an argument, and neither is the court.
Well, that's when I went and filed, that's what they told me that I had to do, because originally I went to go file for full custody, and they said that I have full custody.
Yeah, you have full custody.
Then they said that I had to do a motion in child support. And so.
Well, the case is mostly based on child support because this case was brought to the court by the prosecutor's office, not by either one of you because of state aid.
Right.
So custody has remained with you all this time, and I believe I don't see any other orders concerning parenting time, but parenting time is by agreement.
Okay.
It does state that he has 156 overnights by the agreement that you had. It does not establish what those 156 overnights are.
Okay.
I guess if you're both in agreement, I can send this for a specific parenting time as well. If you're not in agreement, you would have to file a motion, but it sounds like he's going to get his 156 overnights to a certain extent, and except for the ones that you prove that he's not doing because of work. So the presumption is going to be that he does do some time. I just don't know what and when.
Right.
If you'd like that reviewed, Mr. Rubio, it may be in your best interest to have it reviewed as well.
Okay.
Simply because you don't have any specifics. It just says 156 overnights. It has no indication as to what those are. It just says that it's also by agreement of the parties, which means if there's no agreement, there's no parenting time.
Okay.
That should protect both of you. That also prevents you from having to file another motion, from each of you having to take off work again. And then the fees have been waived by the court, so I'll send it for child support and parenting time.
Perfect.
All right. Have a good morning.
Thank you, you too.
Sometimes I can work them out. I
Thank you.
generally have to give the standard procedural method to jump through the hoops. Okay.
Right. Thank you.
All right. Because otherwise, try to stay with the law. But I also try to help you all out. And if I can do that by moving you along, and let's not have some, there are other times that I can't do that. I have one side saying no, and I'm like,
Right.
okay, then we got to file the motion.
Right.
All right. Have a good
All right.
morning to both of you. Good luck. The front of the court will be contacting you in the next probably 3 or 4 weeks to
Okay.
set up the time. Okay.
Okay, thank you.
30DP. Miss Bashir, this is your motion. What do you care to add to it?
I'm just trying to work out something or get things changed because it's very chaotic for me.
All right, we can barely hear you. Let's double check that connection.
Okay.
You are not coming in
Can
very
you hear me
well.
better now?
Yeah, now we can hear you better.
Okay. I'm just trying to reach a resolution because it's been very chaotic for me because he's just doing whatever he wants.
All right, I have you've laid out some allegations here. Is Child Protective Services currently involved?
No, they are not.
Did they substantiate any case against him?
No, not at this time because nothing could be proven with her age.
Okay, is there charges pending?
No, there's not.
So your complaint about rape has not been verified. Child Protective Services has investigated and not done anything.
Well, these allegations were made, and I didn't know what to do with the information because the person in his home is 18 years old. So if she's not pursuing a case, but my thing is, I need to protect my own child, regardless of what they have going on.
Well,
but
the child is both of your children. You are not the only parent here. He is a parent as well, and you guys entered into an agreed parenting time order. And that was it was barely a year ago. So, how's the child doing in school?
She's only 2 years old.
Oh, she's only 3. Okay. So, you've made some allegations here that could be concerning, but it sounds like they've been investigated by Child Protective Services.
No, what I found out, it was told to me by a family member, and I didn't know what to do with that information.
Okay. Well, at this point, if they've dropped the charges, there is nothing. So you don't have a license, correct?
Yeah.
All right, sir. That means that you're going to be doing a lot of the transport here, not her.
That's fine. Could I say something?
What do you have to say?
There's multiple instances throughout this with the current court order that we have, and I even have text messages that I can send to you guys of her stating in court order. And
the court order is what the court order is.
I understand that, but there's been multiple instances where she refuses to follow it, and I even have.
Well, if you have times that she has refused to follow it, the only thing I'm going to change is I'm going to ask you to do the transfer. Do you have a license, sir?
Yes.
All right, ma'am, when do you think you'll get your license back?
I'm not sure yet.
All right, the only thing I'm going to change in the previous order for obvious safety of the child, because I don't want mom being pulled over and then having to get arrested because she doesn't have a license. I'm going to change that to say that you do the transportation, sir. Now, if you show up to pick up the child and she refuses to give the child over, then you file a complaint with the front of the court parenting time. They have a division that does show cause hearings just like they do for child support. Okay?
I would also like to get his timing changed because he's changed jobs multiple times and he's just leaving my daughter with his roommates and his girlfriend.
What's going on with it?
While she's there.
Okay, so he has to go to work, so he's arranged for babysitting for the child. Do you work, ma'am?
Not at this time.
Okay. When you do work, do you have a babysitter?
Yes, I do. I was taking care of his sister full time as a babysitter and paying her for the last 2 years.
So you have a babysitter as well?
No, I don't. Not any longer.
Well,
She's no
not
longer,
right now because
I'm no
you're not
longer
working.
supporting him.
But when you are working, you
Well,
have one,
no,
correct?
I chose not to.
Yeah.
No, I chose not to take care of her, his
Okay.
sister anymore.
At this point, I'm going to make the change on transportation. That's the only change I'm making. And otherwise, the order will be enforced that you guys agreed to last year. All right. Have a good morning. I'm denying your motion for any changes other than the transport. All right. Have a good morning.
You too, sir.
I don't think they realize that once Child Protective Services investigates and finds nothing wrong, that it's kind of a big tip-off that nothing's wrong. I would have invited the prosecutor, but I was informed by the front of the court that there is a justifiable change of circumstance to have child support reviewed. So, because we just entered the order in June. You were homeless and not working at that time. That was on the record. I will note as well that we kind of encourage you to good luck finding a job, but it sounds like you have found a job, correct?
Yes, sir.
And you are living with a roommate or living with a friend for now?
No, sir.
Okay. Still homeless?
Yes, sir. I just been staying from family member to family.
Okay, so you've been couch surfing.
Yes, basically.
Yeah. Well, the front of the court had information that you were actually living with a friend, but that you did find a job, and that's the change of circumstance to have child support reviewed.
No,
okay.
Yes, sir.
So I'm going to grant your motion, and I'll send it for a child support review.
Okay.
Any questions?
Also, is there any resources or anything to help me find?
That's what I was going to bring up next. Have you been to the Department of Health and Human Services to see if they can help you with maybe Section 8 housing or HUD or anything?
Yeah, but they won't because due to my record, they said.
Oh, your background?
Yes.
Then my suggestion might be to call 211.
I get food assistance from them, but
okay. But they won't do the housing because of the other background issues.
Yes, sir.
Because there are certain things that you cannot live in HUD housing if you have in your background.
Right.
I don't know. 211 is an informational system that's run by local nonprofits, and maybe they have something for you. They may not. I mean, the worst they can tell you is no, and if they have something for you, great.
Okay.
That's the only thing I can think of off the top of my head. All right.
Thank you.
But I wish you very well. I wish you luck. Congratulations on getting a job. At least that's the start of getting you back on your feet.
Yes, sir. Definitely.
All right. Take care. Get some sleep. Work hard.
Okay. So how does the next process work?
The next process will be that I'm going to send this to the front of the court. The front of the court will be contacting you. The question is, what's the best way to get to contact you?
Through my phone.
Okay. And I think we have your number. It's a 313 number.
Yes, sir. Yes, sir.
Okay. So hold on. Something else is coming through my feed. All right. So yeah, I'll note to contact you through your phone. Okay.
Also, since these judgment or everything been the support been in order, due to my situation, also I have been having trouble as well seeing my son.
Right. Has she been cooperating at all? Well, when you're homeless, it's kind of hard to have some place to go for parenting time. So we got to kind of, all those are issues that need to be dealt with first.
Right.
And then we'll start getting you to see your son.
Right. But I also at least be able to see him. His second birthday is coming up, and
unfortunately, right now that order gives her control. It's parenting time by agreement. You have the right to ask the front of the court for a mediation, because right now I'll tell you they may not order much parenting time, and it would be supervised at your expense because of your homelessness. So I don't want you to set you up for a double failure. We need to get you on your feet and get you a stable place to live so we can get you some parenting time with your son, because your son deserves a stable place.
Right.
I don't need him meeting you at a shelter.
All right.
Okay. So let's cure this and then we'll deal with the other issue. Okay. No problem. Well, don't thank me yet. Hopefully we'll get you back on your feet and everything will be doing very well in a year. All right.
Yeah.
But I expect a parenting time motion from you maybe sometime around December, January. Because I'd like to think you can stabilize yourself in the next 2 to 3 months. You've done pretty well so far. Okay.
Okay. Thank you.
Good luck. Have a good day.
You too.
Mr. Lucas, this is your motion. What do you care to add to it?
Well, I apologize if I made everyone wait. I was sitting outside the waiting room.
No, I've got a bunch of these things, so nobody's going to notice that. We do them cattle call.
Yeah, I'll try my best to keep this quick. Clearly, I don't have legal counsel, and I'll just say it. First and foremost, thank you for joining me. I'm not trying to waste anyone's time. Contrary to plaintiff's claim, this is not frivolous to me. I'll try to explain. So just quickly, I guess, to address changes since our divorce, to hit those quickly. And I want to make clear I don't feel any of my claims towards Ms. Stroud make her a bad mother or that my children are in a bad environment at all. I think she's a wonderful mother. I'm not questioning her home at all. So since our divorce, changes that have happened. At the time of divorce, I had a 2-bedroom apartment. My kids were sharing room, and my future residence was uncertain. At this time, I've secured a permanent home. Each child has their own dedicated bedroom. I live alone in a wonderful neighborhood in their school district. It's a dead-end road. There's a 5-acre park, 2-acre park, I don't know, right up the street from my house for them to explore. We have a wonderful neighborhood for the children to live in. There's kids everywhere. The coach of my son's basketball team is my neighbor, and her son, Ruben, is 2 doors down. I have children across the street that when my kids aren't here, they're in my yard playing on the swings I put up, catching toads in my pond. I have a loving, perfect environment to raise my children in. Additionally, since our divorce, with everything happening within the divorce, the chaos of it, I personally accelerated my career through all of this. The day I was removed from my home, I started with a new firm, Edward Jones. Since our divorce, I've accelerated. I'm basically, we have levels of reps at our company. 10 is the highest, and I'm almost halfway there already. I've crossed level 4. I took a branch that was going to shut down, and it is now a functioning, profitable operation. For the first time in the company's history, I've hired an employee there to help me run the operation in the office. All of that shows to my children a successful father, that can lead. And so that has changed. Since our divorce, I've had countless overnights with the children. In my mind, when I'm with them, I only add positively to their life. They spent the entire Christmas week with me with no issues, unsupervised with the kids. In March, I flew to London, England with the children for a week, unsupervised completely. We toured England, went to Stonehenge, went to Liverpool, on the other side of the world. No problems at all. Nothing.
Right.
It was great.
All right. I'm going to, I'd let you go on, but I've also read your motion. Ms. Bryan's response was restrained. Legally, if you had an attorney, he would have told you not to file this motion. There is no legally sufficient change of circumstance to grant your request for an increase of parenting time at this point. Okay? There's got to be a change in the child's life, not your life. Changes in houses, changes in income are not by law the ability to change what you're asking for, because you would change custody. You have quite a lot of parenting time as it is. But at this point, it's going to take a lot more to jump it to the 50-50 that you're asking for. That's not going to happen at this time. You are spending time with the children. That's what's supposed to happen. It is going according to what's in their best interest right now. But the law basically says once the kids get used to something, we don't change it unless absolutely necessary or there's some change of circumstance inherent in their lives that require the change, not increases in your life. You know, you don't get married to a millionaire saying my life is better, I need more parenting time. That's not going to happen. But that's a really enhanced example of what you're trying to argue. I've read your motion. Everything that you've stated by law is not a change of circumstance for asking for what you did. So I'm going to have to deny your motion. Ms. Bryan, I thank you for your response. It was pretty much what I had in mind anyway after reading it, because I read his motion a couple of times and went, let me try and find something. Because if I can, I'll try and find something to change parenting time. But this is a change of custody, not just parenting time.
I understand.
So,
I
yeah.
could add one thing.
Sure.
I understand and respect that. I'm not asking for custody, and
technically you are.
Okay. But
technically you're asking for a change of custody. You can couch it as parenting time changes all you want.
I accept all of it 100%.
Yeah, well, I'm just following case law and statute right now. This isn't, you know, I'm applying exactly what you said. I mean, there's case law that actually gives the examples of what you've given and says that ain't it.
Okay.
Okay.
I accept that. And I guess the only thing that I want to say is, you know, I understand my language and actions have made it seem very impossible for me to work with on this.
Well, you have had an interesting history, but I'm discounting that. I'm just going on what your motion is right now.
Absolutely.
You have what you had. It was very long and protracted arguments to get you what you've got. The children are thriving. They're doing well. No one's filed a motion to have your parenting time reduced because of some issues with the children, which indicates that things are going well. Enjoy the time you have. You have quite a bit, which, yeah, it's not 50-50, but it's, you know, you enjoy the time you have. Take care of the kids and then settle them in. Let their lives settle. Okay.
I'd like, before we depart, just use this one moment to ask Ms. Stroud, you know, I believe we could really, if we can communicate, we can solve this. And that's all I want.
Sir, I'm going to just stop you right there, because what you're asking for is the ability to browbeat her to get what you want. That's been your past. That's been what's going on. Enough. So don't even start that.
I want what's best.
I've been trying to do, no, you want what's best for you. That's what this case has been about for years. That's what you've been doing. I tried to play nice here. I tried not to bring up your past. I tried not to rehash stuff. But no, you're not going to browbeat her and continue to get more and more and more. Enough.
I disagree.
Motion denied. Yeah. Don't continue this. I'm reserving the right for attorney fees for frivolous motions in the future. You went too far. Have a good morning.
I'll prepare the order. Thank you, Your Honor.
Thank you. Tried to play nice. I tried not to bring up his past. I tried to give him a chance.
Would you like a little break?
Do we have any other match sets?
We do, but not until it's a 9:30.
In this matter, there was an ex parte order issued by the court because of Child Protective Services involvement. Were there other issues besides the Child Protective Services that I'm missing? Anybody?
Go on, Ms. Lawrence.
There were allegations that the minor child. Okay.
Yeah, I know but that's part of the CPS investigation.
Yes, correct.
The prosecutors got involved as well, correct? But there has been no Did the prosecutors get involved? They tend to on cases like this. That's why I'm asking.
I didn't see any involvement.
No, Your Honor.
Yeah.
Mm-hmm.
I was just asking. So there was no police involvement then?
There was a police investigation that was closed, but I have no indication that the prosecutor's office was involved.
Oh, okay. I guess I misspoke. I should have. I lump those two together sometimes. But yeah, the investigation occurs and then the prosecutor may or may not approve. But if it stopped at the investigative stage, that's a whole nother matter too. That just means there's even less here than what was happening. But at this point in time, the ex parte order was granted on that basis of Child Protective Services. Normally, my explanation is if it comes back unsubstantiated and the police do not do anything, parenting time immediately goes back to the way it was. I mean, pursuant to case law, if a circumstance occurs and it's appropriate to temporarily suspend or change parenting time, that's great. But if the circumstances is alleviated within 11 months, it goes back to the parenting time that was previously done immediately. Because basically, you're basing the removal of parenting time by no clear and convincing evidence at all. You need clear and convincing evidence to stop parenting time. The court will jump through that hoop for Child Protective Services to say, look, until this investigation is done, hey, we're going to be safe. Because forgive me, I have had cases where Protective Services is investigating and the court has forced the parenting time and Child Protective Services removes the children from both parties because they say that the other party then is exposing the children to someone they have a concern over. And the next thing you know, the children have spent a weekend or a week in foster care, traumatizing them, which is why the court suspends parenting time to keep that from happening. But once the investigation is complete, it immediately goes back because the circumstances you were granted the ex parte order on have been alleviated. Now, I've read I will reserve on makeup parenting time, but I will say that this was done by a medical exam and everyone was concerned. So I'm not going to grant makeup time, but the time goes back immediately. If this was his weekend, he gets it. Okay. Any questions from anybody?
No, thank you.
Your Honor.
Okay. And if you want to know the case that is tangentially associated with that is Thoreau versus Dorr. And that case basically says that one parent can temporarily, and that it's a stretch that CPS's involvement, but it's the basis for the fact that it's a temporary solution to a problem. Let's say a parent is moving homes and knows for 6 weeks the move is going to be very emotionally problematic. So they tell the other parent, can you watch the kids for 6 weeks? No problem. Do so. After the 6 weeks, it goes back to parenting time. We want the parties to agree for the safety of the children to do temporary arrangements, basically. Okay. If it becomes more permanent, like it takes over a year, that's a whole nother matter. We have a change of circumstance, but we're talking just a few weeks here. So no, it goes immediately back. So, Mr. Browning, I'm assuming you'll prepare that order that the previous parenting time will start, and it will start verbally. I'm saying it starts today, and that's what should be in the order. So I don't know what the parenting time was or where it left off, but it begins immediately because the circumstances have been alleviated.
Thank you, Your Honor.
I'm sorry your child had to go through such trauma. I don't know what the cause of it was, but at the same time, there is no legally sufficient basis. Child Protective Services has a preponderance. Well, they have if there's a justifiable belief that the child is in danger. That's not even a preponderance of the evidence. We need clear and convincing evidence to stop parenting time. So that's generally what happens is Child Protective Services can come in and it can be utilized as a sword to stop things. But if they investigate it, they find nothing, it becomes a shield, protecting the other side, saying nothing has happened that we can substantiate. And that's where we're at right now. Okay. Good luck to everybody. I'm sorry, ma'am. I'm sure you are concerned, but the parties that are obligated to investigate this have found nothing. And both of these parents are the parents of this child. So we don't stop that from happening unless there's really good evidence to stop it. All right. Have a good morning. Good luck.
Well, Your Honor, I do have one thing to mention. So even though parenting time does start, if we were to continue, the next weekend would be October 4th. If we were to continue, because
then that's where it goes, because I want it back to the stabilized parenting time.
Yep. Okay. So October 4th.
No problem. And I'm sorry this happened to everybody. I'm sorry I'm not giving you all the relief you asked for, Mr. Hockingberg. I just want the child back to normal.
Yep. Thank you, Your Honor.
Have a great morning. Good luck. Miss Lawrence, any questions?
No, thank you.
Okay. Sorry for the explanation, but this is one I give very often. And I don't know if the judge has given that explanation, because I know the judge did this, but normally I'm the one that starts this because she denies the ex parte order. She very rarely grants them. So this is unusual. Normally she denies them and says Child Protective Services is the one to protect the children. If they think they're unsafe, they will remove the child. This is the first time in over a year and a half I've seen her sign one of these. So normally it starts with me because I then get the motion and then I explain the suspension of parenting time and how the process works.
Just for the sake of clarification, I was not involved in the case when the ex parte order was granted. Would the judge have typically given this,
I don't, that's what I was asking. I don't know if she did or not, but let's face it, I've been doing this for 18 years. She's been doing this for a year and a half. I didn't even do it at first. I only started doing that explanation after I had a case where one of the other referees ordered parenting time to be enforced. And Monday morning, I had the neglect case where the protective services had removed the children on Saturday morning, saying that they had concerns. They told the guy not to give the kids to the mother. They had concerns about the mother. When they found out he forced the parenting time, even by a court order, they removed the kids, and the kids spent the weekend in foster care. So I started coming up with this explanation to explain why the court does what it does with child protective services cases.
And I really appreciate that explanation and this justification. I don't know what you can do, if you can do anything about this, but the judge also prepared the ex parte order, and there's no mention of reverting back to parenting time when the CPS.
Yeah, I know it, but the ex parte order is now being dismissed. So the only order of the court left is that. And Mr. Browning, you should put that in the order that the ex parte order is being set aside.
Yes, Your Honor.
All right. Yeah. So I don't know if she gave that explanation or not. Like I said, it took me years before I came up with it. And it took a slap in the face, basically, to me that, oh my God, they will remove the children if we force parenting time. And that was the first time it happened. The second time was even more convoluted, so I won't go into that. But, typically we learn what we learn over time.
Sure.
All right. And the idea is to protect the children and keep them safe as best as possible. And again, CPS is the one entrusted with that. So like I said, I've never seen her sign one of these. I've seen a lot of them that she denies. So I don't know who filed for it, but ma'am, whoever filed for it did some very good legwork in getting it set up. All right. Take care, everybody. But now it's come to where it is. All right. Have a good morning.
Thank you.
DS. Let's deal with the easiest issue first. I will note that, unfortunately or fortunately, depending upon your viewpoint here, because you both have two very differing opinions on this, Ms. Muir does have sole legal custody. It is pursuant to statute. And that starts it, but the affidavit of parentage, which was signed, which made him the father, gives the child the rights of a child born in wedlock, but it does not give the father the rights of a husband. It also, in that order itself, gives presumptive sole legal and sole physical custody to the mother. So he signed the document that gave it to her. When the prosecutor brought this case, the prosecutor is not allowed by law to deal with those issues. They are here to deal with child support for the benefit of the state. State aid was involved in this matter, so neither party brought this case. The case was brought by the state of Michigan to allow the state of Michigan to collect its portion of the child support to reimburse it for what it pays. So the only reason that custody was even mentioned, which is physical custody in the prosecutor's order, is because that has to be a determination under federal law and state law to give those benefits and to maintain them. That's the only reason this order was put in place, was to maintain the underlying issues. The parties, I will note, then did enter an agreement on 50-50, I believe, at some point.
Yes.
Okay. The one thing both of you have said that I really need an answer to is that I don't know how long the 50-50 went on, but both of you have acknowledged that it went from a Sunday to Wednesday. Every other week? Or every week? Every other week.
Every other.
Heck, the Sunday through Wednesday is mentioned, but I didn't quite get whether it was every week or every other week. When did that start?
That's been the pattern for a few years, Your Honor.
Okay, so the Sunday through Wednesday has been going on.
No, we were doing Monday to Monday instead of Sunday to Sunday, and
when did the Sunday through Wednesday start? That was my question.
Never started.
So you've been doing week on, week off parenting time all this time?
Correct.
Despite the paperwork that's been sent to the court. Okay, because that can continue. Week on, week off can continue. The problem is where I started with this is she has sole legal custody, and I went through the legal ramifications of that and the legal justification, which means, yeah, she can change the school system. You need joint legal custody to be able to interfere with that decision. You don't have it right now. So yeah, she can change it to Muir. But I think this does go to, I think both parties kind of agree that it's got to go to front of the court for parenting time.
Yes.
I don't change any previous orders. So if you can make that week on, week off happen and it continues and it does well, you're good to go. It's not going to change.
Well, yes, Your Honor. My client won't be able to bring the child to Muir for
Yeah, I know. I was trying to give him the out.
Yeah.
I tried. Okay.
Yes, I understand. I understand.
Because that's the law. I don't change custody motions, which essentially this is, on a Friday morning. But I do give the opportunity for parties to maybe work it through. I've seen it happen where, they do make the arrangement and it does work for the parties.
Yeah.
I've seen some very strange ways of doing it, like grandma lives near there, so during the weekdays, dad stays at grandma's house on his weeks and then goes back, and the child's life does not change. The child just goes to school. Normally I would tell you that the school issue, the child would go back to the original school. But unfortunately, the motion was incorrect in the fact that there's joint legal custody. There's only sole legal custody. Ms. Brandsdorfer, any questions from you?
No, Your Honor. I think we proposed that it go to front of the court, though, as a more cost-effective way to look at parenting time. And in the meantime, we did invite Mr. Browning and Mr. Christie to submit a proposed parenting time schedule, because Ms. Pratt does want to facilitate that relationship and allow parenting time to continue in a way that works for him.
And it may be that, just because the change of circumstances has been afforded by the move, it may be that she doesn't maintain custody, he does. They've been doing week on, week off. What I am going to do is I will send this to the front of the court for legal custody and parenting time and child support, pursuant to Sims versus Verbrugge, which is a case out of the appeals court on this specific prosecutor order. The reason I'm doing this is the court has reviewed the file. As both attorneys know, a custodial environment can be created in violation of a court order, without a court order, or in compliance with a court order. We have a court order that doesn't give legal custody. It's not addressed by a court order. Sims versus Verbrugge says that means it's open. So I'm triggering it because since there's been week on, week off, I am jumping to a potential presumption that a legal custodial environment may also have been created. Because while it says custodial environment, it doesn't define legal or physical. From my reading of the case law and the statutes, that includes legal and or physical. So legal custody is still custody. He has requested custody in his motion. He thought there was joint legal. I think if he'd have realized there wasn't, he'd have argued for that to be reviewed. Now, if there was not a joint legal custodial environment established, then he will not get legal custody. It will remain sole legal to her. But I think that does need to be looked at, and the parties get to argue that as to whether it's, yes.
I do want to point out that we have not been doing week on, week off for a few months.
I just had that argument. That was one of my questions. And I heard two different statements that it had been happening. It hadn't been happening. It hasn't started yet. Actually, I heard three statements then. So that's your version.
Okay. I just wanted to add that I have.
What, Ms. Brandsdorfer?
I was just telling her she and I can talk about that later.
Right, no problem. Yeah, like I said, that's the reason I asked the question, because nobody put in when it started. Because I do have in one of the motions that it started from Sunday to Wednesday at some point. He's saying no, it didn't, that he's had week on, week off. You're saying no, yes, he did. I'm hearing that it went on for a while. I'm hearing that week on, week off has been going on until current. So I don't know which of you is correct. I'm hoping somebody kept calendars. So in any event, but this is going to be a $300 charge, $150 to each party.
Thank you, Your Honor.
You both set this up, and therefore you're both going to have to pay the fee. All right?
All right. And are you submitting the order?
I'll submit the order of reference.
To prepare anything?
No, I'll submit the order of reference. Along with it will go all of your pleadings.
All right. Thank you very much.
Okay. Take care. If you have any questions or need a settlement conference now or in the future, contact my clerk.
All right. Thank you.
No problem.
Thank you, Your Honor.
Thank you.
Just side note.
Yeah.
We have a support mod for that case.
Oh, you're on one of the support mods. Those are at 10:30, John.
No. So for this case, because didn't you send it for child support?
Oh, there's a pending child support motion.
We have a support mod hearing like next week or something.
Yeah, on October 10th. I'm letting that one go. We're going to keep that one.
Okay.
Because then I'm hoping somebody could tell me when the Monday through Wednesday started.
Okay, sounds good.
Because that would be pertinent to that one, and it may be then that I negate the child support motion on the other, but I don't know how it's going to vet out. So that's why I kept that.
Okay, thank you. I just wanted to triple check on that.
And thank you, because I should have mentioned that to Ms. Bransdorfer as well. But Mr. Browning, if you call Ms. Bransdorfer and say that, as an aside, I said I'm keeping that October 3rd hearing.
3rd or 10th, Your Honor?
Whatever it's. I thought it was October 3rd or October 10th or. I don't look at next week yet. I'm still trying to get through this week.
October 3rd.
All right. October 3rd?
3rd.
Okay. October 3rd then.
Okay. I will.
She has a better grasp of my calendar than I do.
Yeah. I know the feeling.
Mm-hmm. Our assistants run our lives, don't they?
They do.
Okay, we can do Smith versus Jones.
Legal custody, parenting time, and child support. There was an argument, and I got 4 different answers on that Friday, and today is the day we're going to deal with this. So it's my understanding, so the parties are both on equal footing here. We're only dealing with 2 months. This order will go into place, but it's going to be altered again as of September 1st, depending upon the parenting time recommendation. So technically, this order is only solid for July and August, whatever I read. So that the parties understand, what I'm going to ask them shortly is, because the discrepancy is parenting time. The same question that I had on Friday will come up now. The parenting time order does not matter. So the fact that you mediated 50-50, Mr. Christie, is irrelevant. What I need to know is what actual overnights you were exercising since July. Okay. So what are you saying that you exercised as of July 1st? Between that time period until school started.
I was for that time I was exercising as many overnights as I could.
Which were how many?
I don't have an exact number. Okay.
Well, well, Miss Pratt is the one who actually gave the number, because you didn't give any input here.
Mm-hmm.
From the record, they got your pay from federal sources that shows what you do federally. They have access to those. The court does not, by the way, thank God. And I don't want access to anything federal. But so we got your income correct. But the problem is you gave no input to the front of the court. So the front of the court took what Miss Pratt said was what you were exercising. During the summer, were you doing that? Because I know the whole thing was there was a period of time. And again, I got 4 different answers as to when you started exercising Sunday to Wednesday.
All right. So we were doing the mediation, which was the week on, week off.
Right.
And then I couldn't do the week on, week off because of work time.
Right.
So I asked her if we could switch to Sunday to Wednesday every week. And then I could have the front half of the week, she could have the back half of the week. And she refused to do that.
Because that's not what the order is.
Right.
So were you exercising week on, week off? But you're saying you couldn't. So what were you exercising?
I was exercising Sunday to Wednesday on my weeks.
Okay, and that would be
or
Sunday,
Saturday to
Monday,
Wednesday.
Tuesday. So that would be 3 overnights.
Yep.
Every other week.
Correct.
So that would be 3 times 26, which would be 78 overnights. But you had been exercising week on, week off, which is why I think she gave you the 136. Mr. Browning, or 139, I'm sorry. Like I said, at this point, we're only arguing over 2 months. Now, granted, this is what's going to be paid until the new order goes into place. But if you've overpaid according to that order, you'll be given credit for it. If you've underpaid, obviously it'd become an arrearage. I don't know which way that argument's going to go through the front of the court.
Okay. Did the holidays have any effect on a time frame this small?
Probably not, because you're talking about a week
July
at
and
Christmas.
August.
So that's a week at Christmas would only add 4 days because he's already got 3. And spring break would only add 3.5 days because you get every other spring break.
And none of those occurred in July and August anyway.
Well, but I'm trying to combine this
Oh,
for
the
a
rate,
year.
the ratio.
Yeah, I'm trying to
Okay.
give the ratio. I think I'm more than willing to use her 139 overnights, not 78, because I think you
Okay.
do get more than just, and I think you will get more than that. It's going to just depend on how. Matter of
Okay.
fact, I've got a case this afternoon that we did a 5-day trial on, and that's part of the opinion. It's all a school issue.
5 days about school issues?
5 days about, well, no, it's custody.
Oh, okay.
One of the parents did not get the kid to school 67 times during one school year. And they have equal time, and I got to deal with the fact that the kid's got to go to school. So I'm having to make an arrangement where I'm going to try and keep a joint custody arrangement, but deal with the carve out of the school. So it's not an easy needle to thread. But as you see, you two are in the middle of the argument too. It's not one that we're not unused to. But as usual, I'd be happy to go to bed tonight because I dreamt about him the past 2 nights, because I've been rewatching all 5 days of trial. So that's all been in my head. And I think of you with that because I'll give you that example. That's the carve out I'm trying to make. That's not an easy one. I think I gave you several examples on Friday,
Yes.
Probably because they were fresh in my head, because that's what I've been working on another case. And I was not sure until yesterday how I was going to do it.
Understood. Yeah. Yeah. Well,
So, sometimes after you rewatch hearings over time, you get this one moment where you go, okay, that's the answer. It's not a great answer. I don't like the answer, but it's going to be the answer. Because I can tell you, there are many times I don't even like what I have to order. It's the circumstances of the parties. So what I would say is this is an appropriate recommendation at this point. We've got the income correct. We've got the overnights as 139 because they weren't being exercised as 182.5, because actual exercise is what counts. And then we'll see what happens when it changes as of September 1st. Okay, it may go up, it may go down. We don't know. All right. So I'm going to enter this recommendation at this time. Any questions from the parties?
Just at this point, Your Honor, the only thing that I have to say as far as my count goes for his overnights through the summer is about 15 nights. That's it.
Well, and at this point, like I said, we're dealing with 2 months. We're going to get it all corrected and do it as of September 1st. And that may take some time, and we'll see how that vets out. Hopefully you guys can work on that. As I tell people frequently, and it gets a kind of a cocked head, it's like you can leave it up to a dummy like me to make the decision, or you guys can control it. And it's not that I'm not smart. I'm only as smart as those 5 days of trial can make me. So if you think that opinion is going to be great, even after 5 days, did you really tell me enough to actually draconianly lay down a law for your child? Not easy, but it's what I do, and it's what I will do if I need to. Okay?
Your Honor.
But you will always know more about your child and your circumstances than I ever will. So good luck to you. Okay? Take care, everybody. All right. Oh, that one. Oy, okay. You jumped in on a few interesting ones, Jonathan.
I haven't had anything other than Gray versus Nutter with you in a while. Then here they come. Bam, bam, bam.
Yeah, this is all over the place. Do we have everybody here for that one, Rebecca? Let's see.
Yes.
All right. First question. Where's the child?
They are upstairs.
No, okay. Both children are upstairs.
Mm-hmm.
All right. Mr. Browning?
Yes.
Was your client recently arrested in some of this stuff?
Well, I don't think that she was recently arrested. I think that these are a little bit older. These issues from Minnesota. Over the past year, there were some past year and a half, some domestics involving her and Charles. Now, she has related to me that some of these police calls actually came from Tyler, who she thinks is trying to stir the pot up there.
Okay. So the children are still with her in Minnesota.
Yes.
Okay. All right. How old are these charges, Mr. Jones? When did they occur?
The last one that I seen, I believe she was arrested the 26th or 27th of August of this year, pertaining to an aiding an offender for a felony robbery and assault charge.
Okay. So I was going to say, I thought they were more recent than that, Mr. Browning, or at least one of them was.
Well, I got a big packet of things
Right.
from Mr. Smith, but I never got his brief. But
there, there was looks like there was one on there was an incident report as of September 9th of this year.
Okay, he brought this more recently than that. Oh, this was from 9/11. He served that on me by canned delivery. So I don't know if I have anything from September 9 in here.
Well, we have a front of the court report that was recently issued. I'm trying to. When was the front of the court report issued? Did everybody get a copy of it?
Yes.
Yes.
Okay, because obviously, I think you both parties have objected to the front of the court.
Right, yeah. Ours was mostly on the basis of the difficulty in doing what exactly they asked, and because that the school schedule up in Minnesota works a little bit differently. And there are like a couple of 4-day breaks.
Right. And Mr. Jones is arguing that it's completely wrong because he should have custody due to her criminal activities or alleged criminal activities. So we have a pretty in opposite arguments from both sides. I can't change anything on a Friday morning. The reason that I asked the question first was that I presume that if the criminal activity were so bad, Child Protective Services would have gotten involved, Mr. Jones, and probably transferred the children over to you. That's why I asked where the children were, because that's typically what happens between the states. If someone is being such a bad parent that they are ineffective and unfit, Protective Services gets involved, removes the children, and gives them to the other parent. The children are still with her, which is indicia that Protective Services has either been involved and dismissed it or not been involved at all, and only the police have been involved. But you are still allowed to have your argument as to who should be the custodial parent. So, Mr. Jones, I'm granting you that. Understand, Ms. Smith is represented. You are not. You will be treated like an attorney at this point in time. Okay, so you'll be granted the right to have opening statements. You'll have to bring witnesses on your behalf into court and have them testify. Evidence only comes to court through witnesses on the witness stand. So in other words, you don't hand all these police reports just to the court. They have to come in through a witness, generally through a police department or through someone that has received the documents appropriately, because they can be objected to if they're not appropriately entered. So unfortunately, yeah, we're at the stage that you have to be treated like an attorney. My suggestion to you would be to consult with an attorney at the least, because the burden is yours to provide. And I've had people that once they get to these arguments, they show up to court and go, I have no opening statements, I have no witnesses, and then I have no ability to change a darn thing. All right.
Okay.
So that's the warning. And, so you will, any exhibits like the ones you did, have to be prepared in such a way that they can be entered. So you should mark them as proposed exhibits. The court will not look at the exhibits until there is a trial and they're appropriately entered to court. As an example, a few months ago, I had a trial where they sent in 18 exhibits and only entered 4 of them. And then were shocked at my decision because they were like, well, why didn't you see the evidence? I'm like, I saw the evidence you presented. I got the 4 pieces of evidence. I did not look at the other 14 because they were not appropriately entered. So as far as I know, they're just pieces of paper, because anyone can type up anything. So that's why they have to be authenticated by a witness on the witness stand and said, this is a real document. Here's where it was received from. Okay. Mr. Browning, I'm sorry for the explanation. I'm probably boring you to tears, but I want this to be an effective hearing. We're here for the best interest of these children. So it needs to be done in the best manner possible, because there are some concerning things here. Whether they're real or not, or what the outcome of them is, that's a whole nother matter.
Yes, Your Honor.
Yeah, so I will consult with the judge and find out which of us should do this hearing. It may be the judge because of the underlying allegations here.
Okay.
That may be, and I think the judge may get to you quicker and easier.
All right. So we'll just wait for the hearing date?
Right. Yeah, we'll get you a hearing date. Well, obviously it's going to be by Zoom. because of Minnesota being involved. Otherwise, it would be in person. And 5 years ago, you wouldn't have had that choice, Ms. Smith. You'd have had to come here for the hearing.
Yeah, I do appreciate it. Thank you.
Well, it's not an appreciation thing. It's just a reality thing about how we run things now. So, Mr. Jones, make sure any evidence that you are going to prepare is put together appropriately and sent to Mr. Browning at least 1 week prior to that trial. Mr. Browning, whatever evidence you are going to submit also in writing has to be sent to Mr. Jones. So, Mr. Jones, you will be receiving that at least 1 week prior to the trial. So any evidence that he has to refute or say, give further information about some of the criminal stuff that you've presented. But again, you're going to have to find the right witnesses to get that into court.
Yes.
Okay.
Sure.
All right. If you still choose to proceed without an attorney, sir, the Legal Assistance Center on the 5th floor of the courthouse can assist you in obtaining subpoenas to subpoena the witnesses to that hearing.
Okay. Thank you.
Have a good morning, everybody. Good luck.
Your Honor.
Yes.
I did want to let you guys know that the charges were dropped against me. That's no longer an issue anymore.
Well, again, that's why I said that evidence has to be presented. He has the right to present that to the court and show what's going on. Because whether the charges were dropped or not, something happened.
Mm-hmm.
Then the question becomes, was it in front of the children? Were the children traumatized? What's going on? So no, that all is part and parcel of this. That's why I'm saying he is allowed to present his proofs. You were allowed to present your proofs. Because after he presents his witnesses and Mr. Browning gets to cross-examine them, Mr. Browning gets to present your witnesses and Mr. Jones gets to cross-examine them.
Okay.
All right?
Sounds good. Thank you.
So again, Mr. Jones, be careful because you're entering to deep waters and you don't want to get to court and then find out a lot of what you want to present to the court can't be presented to the court.
Yeah. Okay. Thank you.
Good luck, everybody. Take care.
Thank you, Your Honor.
Thank you. And was that the last case with you, Mr. Browning, this morning?
Just 3.
Okay. 3 was enough. Thanks.
Yeah. So there's no need to prepare an order for this one, is there?
No, because it's going to be sent to a hearing. I'm not changing anything. I can't.
Okay.
The front of the court recommendation will not enter because of the objections.
All right.
And then the previous order just remains, whatever it was.
Okay.
Okay.
All right.
Have a good morning, everybody. Take care.
Okay.
All right, Rebecca, I think the Advil and
I was gonna say you sound better.
yeah, I think everything kicked in.
Good. Sound a lot better.
I'm trying to remember because I can't remember whether it's Tylenol or whatever it is. You can take the opposite with the Advil, so I did all of it.
Yep. Okay.
So it's finally kicking in. I should be good for at least another hour.
Oh, that's good. That's what I need you for.
It's nice to be needed. All right, next. Ms. Wolfram, I did not receive a response. Was there one?
No, I was not present at the last hearing and I did not have time between this and now. So I can really only go on what I was informed by the other counsel who did cover for me, who told me that it does conform, but I have to represent my client who has some
who has some concerns, but it was what was put on the record. Because I checked that too. He may have some concerns, but this is what they agreed to, and they were voir dired at that time. So, Mr. Cox, I'm going to grant your motion and enter this order.
Thank you, Your Honor.
All right. I kind of figured that's why you didn't, Ms. Wolfram, but you're right. You cannot sign in derogation of your client's wishes.
Okay.
So, unfortunately, let's see. And I'm going to order him to pay $500 in attorney fees for this because this was just obstreperous, everything comported. It's what was put on the record. The attorney should not have had to, or she should not have had to incur attorney fees to do this, but it's only going to be $500. All right. Have a good morning, everybody. Take care. Mr. Cox, you can get the order for your attorney fees. I think this order is good enough. I will have to add a referral. Well, it's an agreement. No, this is an order from me. I'll have to put the referee language on.
Verbal, Your Honor.
Okay. It should have been signed by both parties, which would have made it entered immediately, but it's got to have the 21-day appeal period on it because I'm making a ruling.
Certainly.
All right.
Thank you, Your Honor.
Have a good morning, everybody.
You too, Your Honor.
Yeah, and I apologize for the attorney fees. We don't often give them, but there's got to be consequences for delay and delay and delay.
Thank you, Your Honor.
All right. Have a good day. Good luck. That was easier. Make me spend time rewatching one of my hearings. Come on, Cornell, you can do this. I know you can. I have faith. Mr. Robertson, you're the only party present. The plaintiff did not show. This matter was set for hearing at 10:30. It's now 10:46. I will note this case was brought by the state of Michigan. The case was not brought by either party. This is a case to preserve the state aid that's being granted for the child. The state mandates that an order go into place. Obviously, this order isn't going to help them. Normally, they confiscate part of the child support paid to reimburse the state, but in this case, we have other circumstances. So I will let the state proceed with its motion, and I'll ask for any input from you, Mr. Robertson.
Okay, Your Honor. Thank you, Your Honor. There was a pre-hearing conference that took place on September 10th, 2024. Both of the parties participated. The defendant receives SSI. Therefore, I am not asking that he pay child support. However, what the issue is, he does not like the language, the custody language, that's contained in paragraph 8 of the proposed judgment of support, stating that mom will have initial custody. The reason why I use that language is because the party signed an affidavit of parentage, and that's the language that we typically would use. The affidavit of parentage in this case is from Indiana. So the party signed an AOP in Indiana for the minor child in this case. However, that AOP that both of them signed states that it says, I do not wish to share joint legal custody of this child, and I understand this affidavit may be still used to establish paternity. So that box is checked that I do not wish to share legal custody. And then the following paragraph states, if you have chosen not to share joint legal custody, the mother has sole legal custody. So I thought it was appropriate just to use the standard initial custody language that we would normally use.
In Michigan, sir, the statutes grant mother initial custody because you can always guarantee who gave birth. You can't guarantee who helped produce the child. So that's why in Michigan that language is. Indiana has a differing format. We used to have a similar one that gave custody if you signed an affidavit straight to the mother without any ability to argue. Our affidavits now state that that is a rebuttable presumption. So our affidavits have changed. At this point, she has sole legal and sole physical custody. That's what the court order. You'll note that the court order does not indicate sole legal because we're not making a determination on legal custody. Well, that's the affidavit. Okay. We only are making a custody determination because that has to flow for what state aid is involved. Federal and state law require that a custody language be done. Custody doesn't matter. When was the last time you saw the child, Mr. Robertson?
The day I signed her up for school, well, the first day of school. That was the last time I seen her.
Which is when?
That would have been August. I believe.
What year?
This year.
Okay, that's what I was trying to get to. Was it recent?
Yeah, well, yes, I had custody of. Well, I didn't have custody. She was going to school and coming home from here, so I got to see her every single day, even on weekends.
Okay, so you see her frequently?
No, not anymore.
Okay, when did you stop seeing her?
The first day of school.
So only about a month, 3 weeks ago? 4 weeks ago?
Mm-hmm.
And you've been seeing her all along since then?
Yes, she went to school every day from my house, every day.
What I can do in that matter is send this to the front of the court for custody, parenting time, and child support issues. Because those are always arguable. The order that the prosecutor has presented is appropriate under the current set of facts. That doesn't mean they don't change. Okay? So the current law would grant her custody, but I'm going to send this for legal, physical, parenting time, and child support to the front of the court. Because this is a prosecutor case, you are on aid, the mother is on aid, the fees will be waived. Okay? That way you have that ability to argue. And one of the factors is if one of the parents is withholding the child, that goes against them. So if she's not letting you see the child because of this, there could be a how far apart do you guys live?
About 2 miles.
Okay. Yeah, I'll be sending this to the front of the court. That issue is preserved. All right. And if you don't mind, Miss Brower, I'll go ahead and send that order on Monday.
Yeah,
I'll sign your order, and then I'm going to grant him the request under these facts to send it straight to the front of the court.
That sounds good, Your Honor.
Any questions, Mr. Robertson?
Oh, yes. On the day of the first day of school, she had came at 2 o'clock in the morning. Well, after the first day of school, came at 2 o'clock in the morning with the police, and the police took her out of the school and everything. She went to another school now, and she didn't go to school until just last week.
Again, those are arguments that you can make with the front of the court. They'll be contacting you in the next 3 to 4 weeks to work this out.
Okay.
All right. I don't have any current court orders to enforce. I'm sorry.
Okay.
This at least makes you officially the legal father through a court order. Okay. All right. Doesn't give you legal custody though. But I'm sending that to the front of the court for you to argue it.
Okay.
All right. Good luck. Take care, everybody. Thank you.
Thank you very much, Your Honor. You
So,
too.
Ms. Brower, your order is granted. Mr. Robertson, I'm granting you a full review. All righty.
Sounds good. Thank
Hey.
you.
All right. Take care.
You too.
And thus it begins. Take care, Ms. Brower.
Bye-bye.
Your request is just to interplead in this matter, correct? At this point?
Yes, Your Honor. I would like to join this matter. It seems that Ms. Crump is receiving state assistance rather than start my own case, since there is one currently existing and well with the court. I would prefer to join. Now, I did notice that on September 6th, a notice of intent to dismiss for no progress was filed. However, if the court should grant my motion today and allow me to join, I can schedule this matter for a pre-hearing conference within the next month. And hopefully get this case moving.
All right, Ms. Crump, the reason that the state is asking for this is because you're on state aid. They presume that if you were going to start a case, that case would continue. Since it did not, and it has the possibility of being dismissed, the state mandates that if state aid's involved, a child support order must enter, because the state will confiscate part of the child support to reimburse it for what it pays on behalf of the children. So it probably is going to be easier for me to let her interplead and continue this case. Otherwise, it gets dismissed and nothing happens. Do you have any questions?
No, I do not.
Okay. So this is to preserve the children's ability to continue to receive state aid. That's why the state is stepping in.
Yes.
So they will meet with you and work on this, and good luck to you. And I'm sure the prosecutor's office will be contacting you shortly.
Okay.
And I'm going to grant your interpleader, Mr. DeHaan.
Thank you, Your Honor. I'll have that order sent to you via DocuSign for signature.
Perfect. Thank you. It's good to see you again.
Thank you. Good to see you as well, Your Honor.
You
Have
take
a great
care.
weekend.
You too.
Thank you.
Take care, Miss Crump. Good luck.
Thank you so much.
Take care. All righty. For the record,
Michelle, you get the next
Nugent, this case was brought by the state of Michigan. The case was not brought by either party. Okay. Miss Smith-Lowe does not represent you. She does not represent the father. She represents the state of Michigan because state aid's involved in this matter. As such, the state mandates to continue state aid, they want a child support order entered because they will confiscate part of the child support depending upon what state aid the child receives to reimburse the state. Okay. That's why we're here. So neither you nor the father asked for this case. Okay.
Yes.
Sometimes that's a bone of contention between people. It's like, why is this case being, it's the state of Michigan and they mandate it when state aid's involved.
Okay.
So I will let Ms. Smith-Lowe, who represents the state of Michigan through the Kent County Prosecutor's Office, place on the record the motion by the state, and then I'll ask for any input from you. I will note that Mr. Cantu is not present, that this matter was set for hearing at 10:30. It's now 10:56.
Okay.
Ms. Smith-Lowe, please proceed.
Your Honor, thank you. I'm here to actually remind the court that we were before Your Honor on September 13th. And we, at the time of the hearing, the parties indicated a change of overnights to 2 nights per week for Mr. Walker. And when I recalculated it, it came to $543. However, after the hearing, I realized that Miss Nugent's adjustment for having one other child was not in that calculation. So the actual child support is $584, and I wanted to reset this so that the parties could,
have an opportunity.
Yes.
Understood. Yes. And now that you have that opportunity, Miss Nugent, anything you want to add?
Well, I do want to add that I don't know if it's something that needs to be going on for longer than it has, but we have changed to 3 overnights the past several weeks, the past probably 2 weeks now.
Okay, so is that 3 overnights a week or 3 overnights every other week?
3 overnights a week.
Okay. So
I can do that, Your Honor.
Okay. Yeah, because it's 156, you have 104.
Mm-hmm.
Okay, we can do that. No problem, ma'am.
Okay. Okay.
Yeah, because this is going from now to the future. So
Right. Yep. Yep.
so if you're going to continue to do that, you may file a motion if that changes.
Okay.
Okay. And hopefully that
Okay.
works out. If everything's working well for the
Yeah,
kid, that's all we ask.
Your Honor,
That's
do you want me to recalculate it now and make
If
the
you don't
order?
mind. Yeah,
No,
can
I
you plug? Yeah,
I
can you
can
plug it in?
absolutely.
Yeah, just plug it in.
So that is, and nothing else has, if nothing else has changed, let me go back and make sure that her
no.
adjustment is in
Okay.
there. Okay, her adjustment is in there. I don't know what happened. That adjustment popped out. It was in the original calculation, but then when we changed it, it wasn't.
Oh, okay.
So
Because it's a
that's
computer. What do you expect?
Oh my gosh, you can't live with or without them.
Right. To err is human. To really screw things up takes a computer.
376.
376. All righty. So that will be it, Miss Nugent. I don't know how much of that you'll get depending upon state aid.
Correct. Right.
All right.
Okay.
So you have a good morning. We'll enter that order. Take care, everybody.
Thank you so much. You too.
Thank you. Have a great morning.
Bye-bye.
All right.